and welcome to part 2 of our redundancy focus video mini-series. During the course of this video, I'm going to talk to you about an employer's obligations towards individual employees in a redundancy situation and how to deal with redundancy dismissals fairly so as to minimise claims or minimise the risk of claims for unfair dismissal. The video is going to focus on the importance of individual consultation in a redundancy situation, what to say during consultation, the timing of consultation, and also provide some guidance on how an employer should convene a pool for selection for redundancy. Before we sort of get into the meat of things, I think there are a couple of headline points to raise at this point, really. The first being that actually there is no mandatory procedure laid down by any statute in the UK which tells employers how to fairly dismiss an employee on grounds of redundancy. The Employment Rights Act, which sets out the statutory definition for redundancy, doesn't actually specify how a redundancy process should be run and focuses purely instead on when a redundancy situation will arise. That obviously being something that we discussed last time around in part 1 of this video mini-series. Although the legislation is silent on the form that a redundancy process must take, consultation must nevertheless be meaningful, and there is plenty of established case law and guidance around on this point, which gives clarity as to an employer's obligation in this regard. Although there is no statutory procedure, employers do need to be aware as to whether or not they have their own contractual redundancy procedure in place. Whether express or implied, if there is a contractual redundancy procedure in place, then that needs to be followed in order to minimise any risk of an employee arguing that any failure to follow said procedure was either a breach of contract or rendered the ultimate dismissal as being unfair. We won't be focusing on collective consultation during the course of this video. Collective consultation will form the subject of a video in itself. However, I think it's important to note at this stage that the obligations with regards to an individual, whilst distinct from an employer's collective redundancy obligations, do interlink. Because when there is a collective redundancy situation, there will still be a need for individual as well as collective consultation. So the two processes will tend to run in parallel, and in some cases they will even overlap. So it's really important to be aware of the individual consultation process when embarking upon a collective consultation process too. In terms of the act of consultation, an employer must firstly be satisfied that the statutory definition of redundancy as contained within section 139 of the Employment Rights Act 1996 definitely does apply. Section 139, as we discussed in the previous video, refers to a cessation or reduction of work of a particular kind at a particular location. And the identification of a genuine redundancy situation is obviously a fundamental requirement of any fair dismissal on grounds of redundancy. However, it's not the only fundamental requirement, and consultation in itself is also a very, very important part of a redundancy process. In fact, it's equally as important as an employer being able to establish that genuine need pursuant to section 139. There are very, very few cases where a dismissal on grounds of redundancy has been considered fair, where there has been no prior consultation. And employers over the years have largely failed in their attempts to persuade tribunals that a redundancy dismissal was fair where there has been a lack of consultation. The case law on this particular point is voluminous, and the courts have probably heard every available excuse over the years. But whether or not an employer believes that consultation won't have made a difference to the outcome of a consultation process, or whether there is only one person at risk of redundancy, it will not remove the obligation on an employer to consult with the employees who are affected. Similarly, it won't matter if an organisation is small, only has a few employees, doesn't have a HR department. It doesn't even matter if the employee says that they don't want to be consulted with. Consultation will still be a requirement. So do bear this in mind when you're embarking upon a process. It's something to commit to, and something ultimately which is going to place you in the best possible position going forward in the event that any dismissal you make on grounds of redundancy is challenged on grounds of fairness. When it comes to the meaning of consultation, as I said previously, the legislation is silent on this, really. However, over the years, it has become very clear that in order for an employer to consult properly and meaningfully, it must approach the exercise with an open mind, so that an employee can still be capable of having some influence over the matters which form the subject of the consultation, i.e., the employee must be able to have some input as to his own destiny. This suggests that consultation will therefore only be meaningful if it happens at a formative stage in the redundancy proposal process, as opposed to when there has already been a fait accompli. There is reams, like I say, of case law on redundancy consultation, but perhaps one of the leading cases in this area is R versus British Coal Corporation and Secretary of State for Trade and Industry ex parte Price. This case from 1994 focused and to some extent defined the key components of a fair consultation process, in the absence, obviously, of any definition being provided by the actual statute itself. In this case, it was made clear that consultation must, as I've said, take place when redundancy processes are still at the formative stage, so an employee can genuinely have input which may affect the overall outcome. The case also made clear that those affected employees should be given adequate information about the proposals on which they are then entitled to respond, and an adequate time period within which to respond. Once the employee has offered their input, the employer must then go away and have a conscientious consideration as to the employee's responses before making a determination about the outcome of a redundancy consultation process. I think it's probably fair to say that employers will often have at least an idea of how the outcome of a redundancy exercise will look right from the outset. However, an employer really must ensure that no definitive decisions, whether you have an idea of how it may look or not, have actually been made at the initiation of consultation or prior to the initiation of consultation, to ensure that that consultation process is indeed meaningful and can be said to have been properly conducted in the event of a challenge. In terms of the subject matter of consultation, the items to be discussed during the individual consultation process will obviously depend on the specific circumstances and facts of the case that you are dealing with. And it's really important for an employer to properly plan for the consultation meeting so they know exactly what they need to say to particular employees in order to make their redundancy proposal very, very clear and to provide an objective justification for such. However, it's probably fair to say that there are 4 or 5 key points which will span all consultation processes. And in my view, the sort of following few things will probably be something that you want to give very serious consideration to including in your consultation process too. The first thing that an employer should very much consider including within any consultation process is the provision of an opportunity for the employee to comment on the basis for their selection, both in terms of the pool and also in terms of the selection criteria, where applicable, that you have used in order to carry out that selection. Secondly, your consultation will probably want to build in an opportunity for the employee to challenge their redundancy selection assessment and also to explain any factors that might have led to their selection and of which their employer might not have been aware. So a very common example in this respect is where an employer has scored an employee a certain figure for absence or attendance, and the employee during consultation explains that actually they have an undisclosed medical condition which has in part contributed towards the inadequate or poor attendance records. In that circumstance, that disclosure will then need to be considered by the employer as part of the selection scoring exercise. The scores may need to be adjusted as a result of that disclosure, and it may have the effect then of scoring that employee overall much higher than one of their colleagues, therefore meaning that actually they are no longer at risk of redundancy and somebody else takes that position instead. The third thing that I think all employers should include within a redundancy consultation process is the provision of an opportunity for the employee to put forward any suggestions for ways to avoid their redundancy. Now, I mentioned this previously already. Arguably, it's a requirement for an employer to afford the employee the opportunity to contribute any ideas that they have in terms of how their redundancy could be avoided. We know that consultation has to be meaningful, and we know that the best way to achieve that meaningful status is to have a collaborative or to take a collaborative approach with the employees in question, so that an overarching consideration of all possible alternatives can be had. Next, I think that a consultation process should include provision for consideration of any alternative employment positions that may exist. Again, arguably this is a requirement, and part 3 of this video mini-series will focus on or look further at an employer's duty to look for alternative employment in a redundancy situation. And finally, I think sort of as a bit of an umbrella point, any consultation should include an opportunity for the employee to address any other matters or concerns that they may have with the redundancy process overall. It's important for employers not to look at the consultation process in isolation as separate to the planning phases, the business need to make redundancies, the selection process, and what is also potentially to come, i.e. possible dismissal or placement into an alternative role. And an employer needs to understand that an employee may have wider questions about why actually they're in this situation in the first place. And as an employer, you need to be prepared to be able to offer your employees an explanation for that. In terms of the timing and the length of the consultation, there aren't any prescribed timescales within which consultation should take place, but it is without a doubt better to have a longer consultation period than a shorter one. The shorter the consultation, the more likely it is that the quality of that consultation will then be called into question. In a case called Rogers and Slimmer PLC, the Employment Appeals Tribunal held that 7 days was the absolute bare minimum that an employer could consult with employees affected by a redundancy situation with. And generally speaking, I think that in straightforward situations, anything between 1 and 3 weeks is probably there or thereabouts. However, you should always take advice in respect of any consultation process that you're looking at initiating to ensure that timescales, along with everything else, are appropriate and reasonable for the proposals that you are seeking to act in respect of. When it comes to the right to be accompanied at a redundancy consultation meeting, if we look at the legislation, which is Section 10 of the Employment Relations Act 1999, it's actually fairly clear that an employee doesn't have a statutory right to be accompanied at a redundancy consultation meeting. The right to a companion extends only to a disciplinary hearing, which can arguably be said to include grievance hearings as well when you look at the wording of Section 10. However, it does quite definitely exclude redundancy situations. That said, it is definitely best practice for employers to allow employees to be accompanied at redundancy consultation meetings, and a failure to do so may, in some circumstances, lead to a risk of a dismissal actually being found to be unfair on grounds of process. At worst, it could lead to a dismissal being found to have been discriminatory if, for example, the employee can argue successfully that they were placed at a particular disadvantage because of a protected characteristic through the employer's refusal to allow them to be accompanied. When it comes to looking at the question of who an employer needs to carry out a redundancy consultation with, the employer must firstly have had proper regard to who is affected by the overarching need to make redundancies, and that employer must then have carried out an appropriate and fair selection through the application of objective selection criteria to that pool of employees. An employer in a consultation process then should really start by identifying the pool, which is the group of employees from which it will select those who are ultimately to be made redundant. If an employer fails to either properly consider the pool or fails in practice to convene the correct pool, then there is a very real risk that any ensuing dismissals may be unfair. Employees might be dismissed who should never have been in the pool in the first place, or employees may have been dismissed when actually they were selected against employees who perhaps themselves should have been included in the pool, but where other employees were omitted from inclusion. Where an employer recognises a union, it will usually be expected that the choice of pool is discussed with the union. So do be aware of that if you have a union in the background, or if you have any collective agreements in place. That said, there are no fixed rules about how the pool should be defined or convened, and unless there is a collectively agreed or customary selection pool, then an employer does have a wide measure of flexibility in this regard. However, there are a number of principles that have emerged from case law which are relevant when looking at the matter of the pool, and which really do support the notion that a redundancy selection exercise can be based on commercial principles and business need. When looking at the pool, there are a couple of points to note. The first being that if a tribunal has to decide whether a redundancy selection was unfair, it must also consider whether the choice of pool was in the range of reasonable responses. So that goes back to the point that I made before in terms of if you get the pool wrong, it might end up in your overall dismissal of any particular employee also being considered to have been incorrectly administered and ultimately unfair. Secondly, the question of how the pool should be defined is primarily a matter for the employer to determine. And again, provided that that employer genuinely applies its mind to the choice of pool, it will be difficult, but not impossible, for an employee or a tribunal to challenge that choice. My best advice to you is to remain objective, or try and have an objective focus when you're looking at the pool. Take things right back to basics. Look at where the redundancy situation is presenting itself. Look at the work of a particular kind that is affected by that redundancy situation and which is ceasing or diminishing. And then look at the employees who carry out that work. If you sort of work on those basic principles, you can't really go too far wrong. That said, every pool, every redundancy consultation is dependent upon its own facts and circumstances, and on that basis, it may be that an employer who is perhaps looking at making some wider changes, is sort of looking at implementing a variety of different pooling methods and a variety of different pools. And there's no legal requirement for pools to look the same across an organisation, if it is indeed the case that the statutory definition requirement of the reduction of or cessation in work of a particular kind also differs, to enable that to be an appropriate way forward. Whilst there are no set rules about pooling, an employer will usually wish to keep the pool for selection fairly narrow. Obviously, the wider the pool, the more employees you have to put at risk of redundancy, the greater scope there is for employee relations issues and or conflict. Some employees within a narrow pool, however, may want to argue that a pool should be wider, as obviously this will usually lower their risk of being selected. But without sort of sounding like a broken record, the pool will be the pool, because it will have to include those employees who undertake that work of a particular kind which is reducing or ceasing. So in some respects, an employer doesn't have a huge amount of control over a pool, because the pooling links with the affected work of a particular kind. In some cases, because of that fact, it will be perfectly acceptable for an employer to convene a pool of just one employee, if indeed it's only that employee who undertakes the work of a particular kind that's relevant for the purposes of the exercise. When looking at the pool, whilst obviously each case will turn on its own facts, there are some factors that are likely to be relevant in most cases, including the type of work, which is ceasing or diminishing, the extent to which employees are doing similar work, the extent to which employees' jobs are interchangeable, whether the employer genuinely applied its mind to the composition of the pool, and whether the selection pool was agreed with the union or employee representatives. That all said, a sensible starting point for drawing up the pool, like I previously mentioned, is looking at what the employee actually does, having regard to their day-to-day abilities and also the terms of their contract. That said, the paper documentation is just one part of things. And in reality, rather than simply focusing on what's in black and white, an employer needs to look at what an employee actually does in the day-to-day. And identifying a pool can become more complicated when an employer realizes that actually some employees are multi-skilled or do interchangeable roles. Because particularly in that kind of case, it's easier for an employee to argue against a selection for redundancy, particularly if they can point to other employees not in the pool who they feel should be. Depending on the circumstances, it might not be reasonable for an employer to identify one employee as being in the pool simply because he's doing the particular kind of work disappearing, whilst ignoring another employee doing different work altogether. It's, like I say, a complicated area at times, and again, advice should be sought on how the pool should actually be convened and who should be included within it, where there is an element of multi-skilling or interchangeable job roles, to ensure that the right people are included for potential selection, so that the ensuing consultation process and ultimately any dismissals can themselves also be considered fair. I hope that you have found that useful, and that you have a good working overview now of your primary consultation obligations when it comes to consulting with individuals. As I've said, part 3 of this video series will look at the selection for redundancy, so following on from what we've just been talking about, how to form selection criteria, an employer's duty to search for alternatives to redundancy, and redundancy appeals.